Hi all. In this presentation, we will discuss the full process of a standard sale transaction of a fee simple property in New Zealand. Along the way, we will also discuss a couple of relevant cases and show how they can prove a valuable lesson for anyone looking to get involved in this exciting space. Engaging a vendor begins with a real estate agent's initial consultation with hopes of understanding the property sale objectives. The agent may then outline the objectives for the property, such as how it may be marketed and what fee the agent may want to commission. After this initial dialogue, the agent and vendor will meet to further evaluate its potential value and discuss detailed strategies tailored to the vendor's needs. For this engagement, agents must adhere to the REAA 2008 Code of Conduct. Specifically, Rule 5.1 requires agents to act in the best interest of their clients, ensuring transparency and loyalty. Rule 6.3 highlights the necessity for accuracy and representation, prohibiting any misleading statements or actions that could impact decisions.
A signed agency agreement needs to be in place. An agency agreement is proof that the client has given the agent the right to market the property. The agency agreement outlines items such as the method of sale and commission payable. A REA-approved guide for agency agreements must be given at this time. Rule 9.6 of the Code of Conduct states an agent must not market any property without a signed agency agreement in place, and if they do, no commission is payable. Andrew Rankin was found guilty of misconduct for forging the signatures of vendors onto agency agreements. Because of this violation of the code, Andrew has lost his license for 5 years and was fined $2,000. Rule 6.4 of the code states that an agent must not mislead a customer or client, which is applicable to the marketing of a property.
An important step in the process of a real estate transaction is when the purchaser wishes to submit an offer. At this stage, it's important to give the purchaser a copy of the REA's approved guide. It is also important to emphasise that they have the opportunity to seek legal and specialist advice. As per Rule 6.4 of the Code of Conduct, it's important that the agent provides the buyer with all necessary information so that they can make an informed decision. If the purchaser wishes to proceed with the offer, they need to do so on their own accord. This is as per Section 35 of the Contract and Commercial Law Act, which states that agents can't pressure people into putting in offers and making decisions. Written notice must be presented to the landlord, even if they think they won't be accepted. This is in accordance with Rule 10.10 of the Code of Conduct.
As the real estate agent, the agent must send a copy to both parties about the REA's New Zealand Residential Property Sales and Purchase Agreement Guide. Both parties then must confirm in writing that they have received a copy of this guide. A sales and purchase agreement indicates that the buyer submitted a written offer. In the agreement, the purchaser sets out details and certain terms and conditions involved by the property. Both the seller and buyer sign the agreement to confirm both parties agreed to the sales and terms and conditions of the contract. The seller can always negotiate the deals offered by buyers. This was shown in the case with Nicholas Dunham. Even though Mr. Dunham was found guilty of misconduct, he was able to arrange the vendor to negotiate a better price for the property. This was effective as it increased the sale price by $25,000. As the vendor is an unsecured creditor, the deposit is advised to be paid to the real estate agent. Clause 1221 of the Real Estate Agent Act 2008 states that all money received by the agent, in respect of any transaction in its capacity as an agent, must be paid in person, legally entitled to the money, or in accordance with the person's direction.
There is a requisition period of 10 working days, where this period is where the purchaser investigates only the vendor's title to ensure that the title is not fraudulent. When selling the property, the vendor must either own the property or have the ability to transfer the ownership. With payments of the deposit, Clause 2.2 of the Sales and Purchase Agreement states that the vendor can't cancel for non-payment except for 3 working days' notice. If the contract is to be cancelled, then proper notice is to be provided. Clause 3.12 states that if any portion of the purchase price isn't paid upon the due date, it can be charged with interest. With regards to the settlement of a sale, one thing that must occur is the vendor's pre-settlement disclosure statement, which provides an update on the changes that may occur. The settlement date is where the ownership and the deed of the property transfers over. This is organized at the start of the negotiation process. The Contract and Commercial Law Act 2017, Section 226, says that there is a legal requirement for signature apart from a witness signature. The settlement is the official handover of the ownership of the property, as well as the release of the deposit, which was held by the real estate agent under the REA Act, Clause 123.
Thank you for listening to our presentation on the 6 key milestones in a standard sale process and a fee simple